am sure you are aware, the district has denied my request to start as a volunteer at the elementary campus. I am here this evening to ask the board to reverse that decision. I am being denied for two reasons: the pending legal disputes between me and the district, and the nature of the prior allegations made against me. First, I will address the stated reason of pending legal disputes between me and the district. My suit against the district has absolutely nothing to do with volunteering. My daughter wasn't even in school. She was only 16 months old when the events that are the subject of this lawsuit took place. So volunteering is certainly, obviously, in no way a part of this lawsuit. Since the district in the past has also acknowledged that the lawsuit itself has nothing to do with volunteering, I will not belabor this point and move on to what is clear. The district means that I am being denied because of the simple fact that I have a lawsuit against the district. In essence, I am being punished for exercising a right. A right to file a complaint against the district in the court. A right that an appellate court unanimously agreed that I have. Why in the world should someone or her children be punished for exercising a right? That is called retaliation. In fact, I have recently read where this district's board policy calls it retaliation. According to board policy, GAA, when I applied for the French position last spring, the reason I was denied the job could not have been because of the fact that I had opposed, quote, unlawful discriminatory employment practices. Now, I know that policy deals with employees and potential employees, not volunteers. However, the spirit of justice, ethics, and potential discrimination is the same in either case. In short, if this district's policy say that it would be a retaliation to deny me the opportunity to teach because I'm exercising my right, it would also be retaliation to deny me the opportunity to simply volunteer because I'm exercising my right. And that's exactly what the district is doing. Moving on to the other reason given for my denial, the nature of the prior allegations made against me. Once again, I have with me, over here, transcripts and findings of facts that show why every disinterested, independent party who has examined this information has ultimately reached the same decision. The allegations are false. Anyone who is interested in the veracity of these allegations is welcome to read through these. A great deal of this information is now available on the internet as well. If you're not inclined, however, to do a great deal of reading of the information, you can see the summary right here once again on my shirt, a copy of my teaching license. Every single allegation made against me was scrutinized before it was decided that I could keep this license. And I got to keep it free and clear. No probation, no reprimands, no sanctions of any kind. There is no allegation that the Texas Education Agency, TEA, and the State Board for Educator Certification, SBEC, are not aware of. And there is no evidence this district has that the state didn't have as well. Every detail of every piece of information concerning the I've Never game was examined. Every detail of every piece of information concerning the coded notes was examined. Every detail of every piece of information concerning the 3 students' allegations was examined. My behavior and my teaching practices were also examined. Everything was thoroughly dissected before the state reached its final, very clear decision. I had done nothing wrong, and there is no reason why I should not be in the classroom with students. Something else important that I want to point out. This is not the same shirt that I wore last year. Since last year, I have received an additional certification. This is important because before the state will grant you an additional certification, you must pass a criminal background check, just as Sunrise ISD requires in order for parents to be able to volunteer. And I passed it. So, not only did the state decide that I should keep my ability to teach in my own classroom, despite the nature of the prior allegations made against me, but as recently as May of this year, the state reaffirmed that decision. If TEA, the agency that governs this school district, says that the prior allegations made against me should not keep me from teaching, there is absolutely no logical, non-retaliatory, non-discriminatory reason to use them as an excuse for not letting me simply volunteer.